Public Law 111-119. 111th Congress. An Act. To amend the Family and Medical Leave Act of 1993 to clarify the eligibility requirements with respect to airline flight crews. Note, Dec. 21, 2009, S. 1422. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Note, Airline Flight Crew Technical Corrections Act. Section 1. Note, 29 United States Code 2601. Note. Short title. This act may be cited as the Airline Flight Crew Technical Corrections Act. Seconds 2. Leave requirement for airline flight crews. Inclusion of airline flight crews, Section 101(2) of the Family and Medical Leave Act of 1993, 29 United States Code 2611(2), is amended by adding at the end the following: D. Airline flight crews, I. Determination, for purposes of determining whether an employee who is a flight attendant or flight crew member, as such terms are defined in regulations of the Federal Aviation Administration, meets the hours of service requirement specified in subparagraph A. II. The employee will be considered to meet the requirement if I. The employee has worked or been paid for not less than 60% of the applicable total monthly guarantee, or the equivalent, for the previous 12-month period, for or by the employer with respect to whom leave is requested under Section 102, and, second, the employee has worked or been paid for not less than 504 hours, not counting personal commute time or time spent on vacation leave or medical or sick leave, during the previous 12-month period, for or by that employer. II. File. Each employer of an employee described in Clause I shall maintain on file with the Secretary, in accordance with such regulations as the Secretary may prescribe, containing information specifying the applicable monthly guarantee with respect to each category of employee to which such guarantee applies. II. Definition. In this subparagraph, the term "applicable monthly guarantee" means I. For an employee described in Clause I, other than an employee on reserve status, the minimum number of hours for which an employer, page 123 Stat 3477, has agreed to schedule such employee for any given month, and, second, for an employee described in Clause I who is on reserve status, the number of hours for which an employer has agreed to pay such employee on reserve status for any given month, as established in the applicable collective bargaining agreement or, if none exists, in the employer's policies. The calculation of leave for airline flight crews, Section 102 of the Family and Medical Leave Act of 1993, 29 United States Code 2612, is amended by adding at the end the following: 5. Calculation of leave for airline flight crews. The Secretary may provide, by regulation, a method for calculating the leave described in paragraph 1, with respect to employees described in Section 101, 2, D. Approved December 21, 2009.